going to be looking at a series of videos on residential purchase contracts in Alberta. So the contract that we're specifically looking at is put out by the Real Estate Council of Alberta, and it's what most realtors will use. One of the issues when you look at real estate in Alberta is that by the time the real estate contracts actually get to a lawyer, they've already been signed off on. And so our hope is that providing some information, opinions, and some pitfalls about what's going on with real estate before you purchase, before you sign the contract, it might help avoid some of the issues that we see at Woodbine Legal Services. So in the first part of our series, we're going to be talking about the parties, attached and unattached goods, the purchase price, what the completion date means, and some general terms regarding a real estate contract. So we're talking about residential purchase contracts, and the one that we have in front of us is the Alberta Real Estate Association's standard real estate purchase contract for residential properties. And so this is the one that most buyers and new buyers are going to see more often than not. Now, I do want to point out that obviously when you get lawyers involved, then people's unique situations are different. So you might have facts associated with your particular property or the property that you're looking at buying that causes these agreements to change and be varied. And so you should really contact a lawyer to look at yours and your independent situation. But we're kind of looking at general clauses today. So the first thing that we're going to look at is the seller and the buyer. And so when you look at the certificate of title, it's going to indicate who is on title. And those names have to be on the list for the seller. Same thing for the buyer. Now, that might seem fairly straightforward, but there's always problems that as a real estate lawyers will run into. And one of those is if there's been name changes. And there's a couple circumstances where that might happen. So one is people get married and they change their name or they hyphenate their name from their prior name. And so on title, it might say Joe Smith, but then you get married and it becomes, Joe Smith Devaney. And so as your seller, you might write Joe Smith Devaney, that's your name now. Why wouldn't you do that? Well, in order to do that, you want to make sure that you're telling whoever's doing the conveyancing for the property, because they'll have you sign a statutory declaration, provide a copy of your marriage certificate or your change of name that you did through Vital Statistics with your land titles documents, so that can get filed and it just shows proof of name. The second common one that happens is estates. So someone has passed away and the estate is now dealing with the property. And in order for a estate to deal with the property, they actually have to file probate with a statutory declaration to land titles. If the property, for example, was as joint tenants, meaning that the people, when someone dies, it just transfers to the other person, then again, there's another form that needs to be sent for that, so that can happen. Otherwise, they'll still list the deceased person's name. So something worth considering, if there has been a change of name, just bring it up, mention it in advance so they can get all the paperwork done, and it's not going to cause a delay down in the future. Then we scroll down, we look at section 1. So the property is, and so what it's asking for is the municipal address. So the street name, the name of where the property is located, 123 Main Street. The legal description is the description that's assigned to the property. And in Alberta, we're extremely lucky with our land title system in that it's plan, block, plot, which makes it super easy. And again, that's just going to be on something like your property tax certificate or your mortgage statement. You can also do a land title search at any registry's office as well to get that. And that is, what are we actually selling? The big thing too is going to be that the municipal address actually lines up with the legal description. And it doesn't happen very often, but occasionally what can happen is that the municipality will change the municipal address, especially in newer developments, to line up with other developments or other sort of expressways that they're going through and adding on. And so again, very rarely, but I've seen that happen once or twice before as well. All right, so 1B and 1C are unattached and attached goods. So an unattached goods are things that aren't physically attached or not by any strict purpose to the property itself. And so when you think of unattached goods, you think of things like appliances, where it's just you unplug it and it pulls out. So lots of fridges and stoves are included as unattached goods. Another common one that I see are window coverings, so like drapes and blinds. Sometimes just because something is screwed into the wall, think of it like bookshelf mounts, doesn't mean that they are attached goods, because you can just simply unscrew the two L clips and it just pops out and you can move it. So we're talking about attached goods. We're talking about things that are actually fixed to the land and the buildings. So sheds and garages tend to be two big common ones. But it can be a variety of things. Mailboxes, right, is another one I've seen. Sometimes planters, again, where it's possible for them to be removed, it would just be very challenging. And when we look at these, it's really important. And sometimes realtors don't put enough focus on these to manage expectations. An example, say, of an attached good that I've seen that people have left behind are shelves in the basement that are bolted to the wall and to the floor, and like that heavy shelving, the metal shelving. And so they'll say, no, these are going to be left behind, right? And again, same thing where it says the attached goods except for, again, might be, hi, we are going to be taking the sign or the mailbox out front that we did for our family, even though it's fairly fixed. And again, I always tell people, list all of the appliances, list the model of the appliance even. You run into those situations where people, oh yeah, it says a fridge. And so they switch out the new, Frigidaire fridge with some 1970 version that they got at a garage sale, and people are disappointed. And then it causes friction, and then it causes, things. So if you list the model and the make of the appliance, the more detail, the better, then you know exactly this is what's going to be in there, and it causes less confusion. Same thing if you mention like the drapes, you can mention all drapes, but if it's not all drapes, mention, the drapes present in the living room, present in the bedroom. And again, the whole point of this is just to be clear about what's being left behind, what you can expect and what not to. So the purchase price is the biggest one. And so that's the one that tends to be amended the most. It's just in Canadian dollars, given that we're in Alberta, how much is the property being bought for? Typically, the purchase price does include goods and service taxes pursuant to 2.2, the exceptions being new home builds. So when you're building a new home, there's GST on it, just like in new purchases. You might also have to sign a document that says that this is a residential property, that it was previously owned, and that you're going to live there for the purposes of doing an exemption to GST as well. And that's a common document you'll see for conveyancing. The contract will be completed and the purchase will be fully paid and vacant possession given to the buyer at 12 noon on this date. A lot of times people under 2.3 miss a couple of things. So this is the closing date. This is when people actually switch into that new house. And what does vacant possession mean? Vacant possession means that people aren't actually there anymore. The most common example where I see there's issues with that is with when people have tenants in their property that they're selling and the tenant doesn't move out as they're required to. Then obviously vacant possession can't be provided. The one thing that, although the default time is 12 noon, which makes sense in a lot of ways, that is a completely negotiable term, even though it's fixed into the standard contract. So if taking possession at 4 p.m. makes more sense because you don't believe that you'll have funds by noon, then change the time. And I don't think I see people change that time enough. But again, it's a negotiable term, and setting it at 2 o'clock is certainly something that you could do. And 2.4 is kind of your catch-all to make sure that when you viewed the property, it's in the same state as when it was accepted. So when that's said, is if you put an offer in, and then you want to put in a counter offer, or they've come back and it's been like a week or two, the wording of how this is written is that it's going to be in the same condition as when the contract was accepted. And the attached and unattached goods will be in the normal working order as of that date. But if it's been 2 weeks since you viewed the property, you might want to go and just take another quick look through the property to make sure they're in that time period, there hasn't been any changes or damages or things like that. Appliances have been switched out. that that you may want to note that might affect you even moving forward in the first place. So now we go to general terms. So a lot of these general terms are to help both parties be clear about what they're actually doing. So again, it points out that seller and buyer agree to act reasonably, and specifically when we're talking about good faith, it applies a higher standard of conduct than what it might be if it was just, say, act reasonably. In good faith, you are having to tell the other person, honest opinions about certain things. And so there's this onus upon someone to actually disclose things that might affect some of these general conditions under 3.1. So again, they basically say that the laws of Alberta apply to the contract, so everyone understands that, not the laws of some other country or some other province. Alberta time applies to this contract, which means that, again, we're using Alberta time, not BC or Ontario time. Time is of the essence is a clause that's in most contracts, and it basically says that the times and dates that are stipulated in the contract, such as the closing date or conditional rule date, which we'll talk about soon, are dates that actually mean something. So when it says 12 noon, it means 12 noon, not 12:20. And so is it a breach of a contract? Well, with this time is of the essence clause in there, it means that yes, 12:20 is breach of the contract because we've said time is of the essence. Again, for definitions, business day means every day but Saturday and Sunday and statutory holidays. And again, reference to buyers or sellers in the plural or singular. Again, these are just standard terms that are meant to try to, get away from the specific terminology or vernacular in case someone calls he a she or she he, and they say, oh, that's a reference to another person, when it's obviously a reference to either the buyer or the seller. So F, the seller will disclose known material latent defects. Material latent defects means a defect in the property that is not discoverable through a reasonable inspection, and that will affect the use or value of the property. So there's two parts here, and this is probably one of the more litigated matters because these are the ones that affect the property value the most. And I think of two particular areas: mold and asbestos. So if the seller knows that something is wrong with the property that's going to materially affect the value, then they're required to disclose it. Now, there's a lot of legalese kind of flowing through that, and a lot of legal definitions that flow through that. But if you had to have the default and, even going beyond kind of what does the law say about anything, I always kind of go through, would you want to know this if you were buying the property? Be fair, be reasonable with the people that are selling it. Don't try to hide something that exists. And now I'm not talking about, and sometimes I see these, like the window that could open and close, the handle broke off, and someone has to go and buy a $7 new one from Home Depot or Lowe's or wherever, Canadian Tire. That wouldn't be called a latent defect because it doesn't affect the material value of the property. A scratch on the floor. Again, it's something that people would, through reasonable inspection, be able to find themselves and point out. Again, thinking of the big ones. The furnace does not work is a pretty big one. And they'll probably find that out when they do a regular property inspection. That there is a hole in the roof, even though it's not visible from the outside because you had some flooding damage. You should probably disclose that to the other party so that they can do their own inspection to determine whether or not that's something that's valid or not. And the best thing to even do is say, hi, this is what happened and this is what we did to fix it. Say no. And you can always say no. You don't have to accept their sales price, but disclose those things. Don't try and hide it. If they say, hi, it's really important to me that no one has died in this house that you know of, right? Just tell them. What you don't want at the end of the day is someone suing you and dealing with 3 years of litigation after the fact, purely because you tried to hide something. And from my perspective, the time, stress, and energy, and then legal costs associated with that aren't worth it versus just finding a buyer that wants the property in the state that you're selling it in. The biggest thing that I would recommend to anybody if they're thinking, hey, do I have to disclose this? Is if you're thinking about whether you have to disclose it, you should probably disclose it. And then otherwise, ask your realtor, ask a lawyer, do I have to disclose this? But, in my opinion, the honest thing to do is if you're asking yourself, should I have to disclose this? You should probably just disclose it as the fair and honest thing to do. And again, the following one under G is the seller and buyer each responsible for completing their own due diligence and assume all risks if they do not. That kind of goes to the little things, right? This toilet doesn't flush as well, or we're talking about items that have built, decades before. You're buying a 1970s house. You're going to assume that a property that is 50 years old is going to have some things in it. And you're hoping that the value of that property and the price that you're paying for is going to reflect those issues. But at the end of the day, what this is saying is that both the buyer and the seller are responsible for performing their own due diligence, hiring their own inspectors, not relying on just what the seller is telling them to do. And I can't emphasize that enough. Get a home inspector, and we'll do a whole nother video about home inspectors because they have their own language, but get a home inspector, get a water inspection if you're in an acreage property, and get that information yourself. If this is a property you're spending hundreds of thousands on, and it's a property that you want to actually live in for a period of time, then do your due diligence up front. Don't just accept it and hope for the best. And again, so we've talked about before under H, the seller will ensure the seller's representatives and warranties are true by reviewing documents such as real property reports, land titles, and registrations on title, determining non-resident status for income tax purposes, and determining any dowry rights and any other research necessary. So the first thing we talked about, and we've talked about this before in other videos that we've done, is the real property report. So real property report is a surveying report which creates a map of your property that outlines these are the boundaries, and these are the boundaries of your neighbors, and these are boundaries of the municipalities as it leads to, say, the back alley and the curb. And this is where your actual fences line up to that. These are your decks, and these are your sheds, and these are the other things that are associated with your property and your fences. And this is where their measurements are. And then that real property report is then sent off to the municipality, and then they ensure that it complied with all building codes. So the reason you do this is so that in creating that real property report, you know that the municipality's bylaw officer isn't going to come by 3 months after you buy the property and tell you, hey, your fence is supposed to be 6 feet and it's 8 feet. You have to shorten your fence by 2 feet. And that's what a real property report is going to do. Or, oh, hey, your back line on your fence is encroaching upon municipal, so you're going to have to, take down your garage because your pad is too far into the back alley. That's what a real property report is going to say. So it is better than anything for that. Kind of as a word of thumb, if the real property report that they're giving you is over than 5 years old, you want to get a new one, or you want to get something else. And this is probably the most common change of any standard form contract that I see, is that instead of a real property report, we are going to offer title insurance. And so what you'll see is people will cross out initial this and they'll say title insurance. Title insurance basically covers the same thing if there is a problem down the road. It's insurance like anything else. So we're just basically assuming, no, there's not any issues, but if there were issues, then the insurance is going to cover it. Again, we test this in kind of other videos in a really quick way. And again, always take a look at our Instagram account. But the big reason is title insurance can be received in like a day, whereas a real property report, as far as booking a real property with a surveyor, might take 2 or 3 weeks for them to come out, and then another week or so for them to actually write up the report. And so we might not have the time to get that done. So they'll ensure to pay for title insurance. The real property report, it might cost a bit more, so it might cost like $600-800, whereas a real property or a title insurance will cost me $150-250. It's around $200 normally. And again, depends on the value of the property, like any other insurance. The more your value your car is, the more insurance it is going to be costing for your car to have. The number one reason why you want to get a real property report is because it is, to the date of the report, accurate. And it will list everything in relation to that report. And so you don't need title insurance because you know what is or is not wrong. And then you can accept it as is. So I just goes into the basically says that the buyer can get independent inspections or advice on any of the documents, insurance, RPR reports, building mechanical systems, etc., that they deem necessary. J, contract charges are agreed to in writing will supersede the prepared contract. Again, it's just saying that if you cross something out or add something in it, those specific provisions prevail over anything that was pre-printed. Okay, again, it's trying to get around the idea that, oh, I just signed this. I did not know. I did not look at it. And so it specifically says in here, the seller buyer will read this contract and seek relevant advice before signing it. So again, you are acknowledging that you've done that. So go up and do it. And L, the brokerages and real estate board and listing services may collect, maintain, disclose, publish relevant information about the transfers, including sale price and date of sale and that sort of thing. And that's included within MLS listings. That type of information is included in to be able to compile data for the government's disguised to tell things like regional economic growth and how much properties are being sold. So that's again standard data collection clauses included in most contracts of this nature. And similarly, you're, again, agreeing that the broker or real estate can provide you with a copy of this contract to the lawyer for the purpose of doing it. So again, just getting around that privacy release issue.